Okay, thank you for getting back and coming to order. So that was a great first session. The second panel is going to focus on a relatively new supervisory or less supervisory and more oversight institution in Washington, the Privacy and Civil Liberties Oversight Board. I have a bit of a personal relationship with the board since I was involved in August of 2004 in the drafting of an executive order that President Bush signed that created its predecessor. I'll confess here publicly, we didn't do a particularly good job of fulfilling the ambitions in that executive order, and the Congress stepped in and made it better, took matters into their own hand. This session is going to be moderated by Ken Wainstein. Ken's doing double duty today. He was a great contributor to the last panel. I think we got his bio in sort of dribs and drabs, but I'll just remind you, Ken was President Bush's last Homeland Security advisor, predecessor to Lisa Monaco, who's going to be our lunch speaker. And as he mentioned, I think he was also the first Assistant Attorney General for National Security. Prior to that, he'd been the Chief of Staff and the General Counsel at the FBI. Also, as he mentioned, U.S. Attorney. So Ken's done most of the hard legal national security jobs in Washington, and he's superbly qualified to lead this panel. So I'll just turn it over to you, Ken. Thanks.
Okay, thanks, Steve. Appreciate it. Good to be back before you again. This I think is an interesting opportunity because what we're going to do here is we're going to take sort of the generalities of our other discussions about oversight and sort of then focus those themes on one oversight mechanism, the PCLOB. And you know, and we're doing so at a relatively early stage in its life. You know, it's only been stood up for a few years now. So I think this would be an interesting opportunity to actually look at an evolving oversight mechanism, think about whether it's evolving the right way. Is it meeting the needs of today as opposed to the needs of yesterday, to Admiral Inman's question? Is it being structured the right way? Is it looking at the right things? And at the end of the day, is it adding value? So I think it's actually a good opportunity. We talked about, or Steve talked about, checking egos at the door, and I think that applies here because, you know, I think this is an opportunity for all of us, you included in the question and answer period, to ask questions about value added. Is value being added by this organization? And I think all three of the panelists would say they want those tough questions to be asked. So with that, let me just introduce the panelists. And so you have three of the board members here, and I think we're very fortunate to have them. David Medine, who, and I'll do this in truncated fashion, has an exceptional career in and out of government, many years in WilmerHale, but also the SEC and the FTC, focusing on privacy issues, consumer protection issues in a variety of different ways, and he'll explain a little bit more about his future plans in that regard too. Rachel Brand, who's in the middle. Rachel and I have known each other for many years. She was in the Justice Department, headed up the Office of Legal Policy, and in that position did everything from, you know, help to get Chief Justice Roberts confirmed, a task of no small importance, but also really focused on the policy issues facing the department. And I think that is be interesting to ask her and Beth, who I'll introduce in a second, about their experiences in terms of looking at issues not only strictly as a matter of legal or not legal, but as a policy matter, whether as a policy matter something should be done or not done. And she's got an illustrious career having done that for many years for a number of different attorneys general. And then Beth Collins, also illustrious career both in the private law firm world, but also in the Justice Department. She and I also have known each other since the mid-2000s. She was the head of Office of Legal Policy as well, and oversaw a range of these policy issues. And now they all sit on the PCLOB. David is the chairman, and Beth and Rachel are members, very active members. I'm going to ask David to start off. His is the only sort of set of remarks we're going to have for this panel, but I thought it was appropriate for him to sort of walk through what the PCLOB is, what its origins were, what its mission is, and what some of the main areas of focus have been for the PCLOB under his tenure. So with that, David?
Thanks, Ken. Thanks, Steve. Thanks to ISP, to the Strauss and the Clements Center. As a member of a multi-person board, I'll take on the responsibility of giving our disclaimer, which is that none of our comments today necessarily represent the views of the board or any of its other members. So Ken talked about starting with 9/11, and I think that's appropriate for our board. Many of you are aware of the 9/11 Commission report, which looks at the intelligence failures that occurred and how we can do a better job going forward, particularly in gathering more information, connecting the dots in a better fashion. And it's a very impressive report. And toward the very end of the report, the 9/11 Commission said, in this effort to get greater information, and let's not forget about privacy and civil liberties, because those are important values and what make our country great. And the 9/11 Commission recommended that an entity be created to help balance national security and privacy and civil liberties as we expand our intelligence activities. And so there have been 3 iterations of our board, and I think what's notable is that with each iteration there's been greater independence of the board, which I think is a critical feature in making the board credible both domestically and internationally in its oversight of intelligence activities. So the first version was done by executive order as a multi-agency entity that was discussed before, and that transitioned into a congressionally created board with 2 of the 5 members presidentially appointed and Senate confirmed, and the 3 others appointed by the president. One of those board members resigned and protested and felt that the board wasn't sufficiently independent because the White House had been editing some of their work, and Congress agreed with that and abolished PCLOB version 2.0, and in 2007 created PCLOB version 3.0. And some of the big differences between the 2 versions is that all 5 board members, all 5 of us, have to be presidentially nominated, Senate confirmed. The board also has the legal power to, if it doesn't get what it wants in terms of information from agencies, to go to the agency head, and the agency head is required to direct their staff, so long as there's no legal prohibition in providing the requested information. And the board can also go to the Attorney General and seek a subpoena for private sector information if it's not provided to the board, and the Attorney General either has to issue the subpoena or explain in writing why the Attorney General is not issuing the subpoena. So our board, I get 4 other board members, including Jim Dempsey and Judge Wald, were confirmed in August 2012, and they got the board operations started and started putting things together. I was confirmed in May 2013 and started the first week in June on a Monday when the board had 2 detailees and no other staff, no email system, no website, and no office. That was Monday. Thursday, the stone leaks occurred. And the question was, is the board going to be relevant or not relevant? So on Friday, I wrote a letter to the Attorney General and the Director of National Intelligence saying the board would like to be briefed on the 215 and 702 programs which had been leaked. P.S. I don't have a security clearance. On Monday, I had a security clearance, and on Tuesday we met at the Justice Department and were briefed on the programs. A couple weeks later, we sat with the President in the Situation Room and talked about how to move forward on these issues. So it was quite a heady, challenging start to the board, and we continue to describe it as flying the airplane while we're building it, because at the same time we're growing our staff and our infrastructure. We were also writing reports. We were asked to and agreed to write reports on the 215 telephony metadata program, and that report was issued in January 2014. One of the central recommendations is that bulk collection of telephone records be discontinued, and as you know, the USA Freedom Act ultimately implemented that with the support of the President and the intelligence community. In July of 2014, we issued our 702 report. It was issued on July 2nd, 702. That was purely an accident. We only realized after the fact. But we basically, in contrast to the 215 program that the board found to be not legally compliant, this program where we found it within its statute, within the Constitution, an effective program. We did make some recommendations, but by and large, the advocates loved us for our first report, not so much for the second report, but I think it shows our independence and the fact that we look at each program on its own merits. We've, since those 2 reports, have turned to studying Executive Order 12333, and this year we'll be issuing a public report on that. To help inform that report, we are also doing what we're calling deep dives, which are inquiries into specific activities that are occurring pursuant to 12333, two for the CIA and one for the NSA. Those will probably remain classified, but the board will decide whether to issue reports on those, but they can be issued in classified form to the President and Congress. We've also made recommendations, which we can discuss later, about the operations of the Foreign Intelligence Surveillance Court. Our basic methodology has been to look at legal compliance issues, some of which were discussed earlier, including constitutional issues. We did that because Congress directed us to do that as part of our oversight mission. But I think what our unique value add in some ways is the policy analysis, where we look at the efficacy of programs and consider them in light of the privacy and civil liberties implications of those programs. Our mission is limited to counterterrorism programs, federal counterterrorism activities, primarily in the intelligence community, but not limited to that if non-intelligence agencies were involved in those as well. And so with that, I will just turn this back to Kenneth.
Okay, I'm going to go ahead and hit the panelists with some questions and then open it up, but if you all have a burning question, feel free to raise your hand. David, just curious, why was your mandate limited to just counterterrorism?
That's a good question. That's what's in our statute. And I have to say, I don't know the legislative history of why that was limited. Some people have suggested, I think the President's Review Group suggested that the mandate be expanded to foreign intelligence generally, but I don't know if you know why it wasn't in our statute.
I don't know why as a matter of legislative history, but I suspect that it's because we came out of a recommendation of the 9/11 Commission, which was, of course, focused on counterterrorism issues and counterterrorism programs. It's one of the many ways in which I think the drafters of our organic statute did not think through how we would work in practice, because there are certain programs that are specifically counterterrorism programs, and there are many other programs, including activities conducted under 12333 that are dual purpose, right? They support a counterterrorism function, and they support counterproliferation, CI, other national security military functions as well. And when you're looking at them, it's very hard to kind of bifurcate your brain and only look at the CT aspects of a program, so it's a challenge.
Just interesting. And day-to-day, operationally, is that a problem? I mean, are you denied access to certain things that maybe the relevant agency might categorize as non-CT and that you think should be within your purview?
The agencies are very cognizant of the limitations of our jurisdiction. I'll just put it that way.
But I think we've also done a fairly good job of explaining to the agencies that we are engaged in a balancing consideration, and it is really not in their interest to fail to inform us about the effective uses of certain programs like 702 that may not be limited to counterterrorism, and it informs our balancing.
And they have done that. They have given us briefings on applications of programs that are not CT applications, but to educate us about how a program works in general.
Give you the context.
Yeah.
Yeah,
Okay.
and I have to say, I mean, in the 702 context, I mean, a lot of my impression about the program was based on some of the benefits of the program outside of the CT context. I mean, and that in terms of the value to the country and the value to how the program operates. And so I think it's actually in the intelligence community's interest to share more information with us more broadly, because it does help us put in context the programs that we're looking at.
Okay. One of the questions I highlighted at the outset is, what is the value add? And Rachel, I'll pass this one on to you. I mean, you heard an absolutely scintillating panel discussion earlier today about executive branch oversight. And, so the question to you is, how do you see PCLOB fitting in with those other oversight mechanisms? Where do you see them filling a particular need or a particular gap that's left by the rest of those mechanisms? And maybe you could speak to that as to sort of the original intent, and then where you see that value add evolving.
I think that identifying our value add is one of the sort of the two biggest challenges that face the agency, because as you heard earlier in the scintillating panel that you referred to, yeah, you were on that panel. It was actually very interesting. It was helpful to me. There are so many oversight bodies in the executive branch already, right? And more oversight is not necessarily better oversight. If it's redundant, then it doesn't add value. If it is redundant and therefore gums up the works, as someone referred to in the previous panel, then that's detrimental. So where can we do something that no other oversight body in the government is doing? And in my view, where we can add the most value is to take a step back, a step up perhaps, and look at big picture policy issues, look at something that Beth has spent a lot of time thinking about. How should agencies assess value, effectiveness of a program, for example? Are there questions that are not hot buttons, so therefore no one's looking at them, but they're important that we could really add value on, that the agencies aren't asking themselves? It's that sort of thing. It's not the, let's look at this particular legal question that courts have already looked at and agencies have already looked at, and we may have a different opinion, but I'm not sure that's where we really add value. And I think that challenge relates to another challenge, which is the fact that our mandate is twofold. It's oversight, but it's also advice. David, did you mention that?
I was going to, but go ahead.
So in our organic statute, we are supposed to oversee counterterrorism programs, and we also are supposed to provide advice to federal agencies as they're constructing programs. And that is it's really hard to combine those two functions, and that's another area where I'm not sure the drafters of the statute really thought through how that would work, because if you take it into a different context, you would not, if you were at Justice, like Beth and I were, you would not go to the Inspector General for advice on something. You don't usually go to your overseer for advice on how to do it in the first instance. And yet we have these two functions, and we have to figure out a way to do both of them well. And so to perform our advice function well, we have to establish credibility and trust in the intelligence agencies. To do that, we have to demonstrate to them that we understand how they work, we understand their mission, and we're there to help them do their mission better. At the same time, to be credible in an oversight function, we cannot be too cozy with the IC or be perceived to be too cozy with the IC. And so there's a tension there, and we're getting there, but that's a real challenge in setting ourselves up.
Well, since you raised it, that's one of the things I honestly, until I was preparing for this panel today, I didn't realize you had that second function, the advice function. Maybe, Beth, you want to feel that? How well is that working? I mean, are you finding that the channels are open? Are they seeking advice? Are they taking advice? Are you giving it?
I think the advice function is going to be critical to what we do going forward, particularly given the nature of the types of programs that we're looking at often, or the types of issues which are classified. We found ourselves in a very unusual position to begin with when we were opining publicly about 215 and 702, and I think one of the things we brought to the table was a very clear explanation of what 215 was, what 702 was, and what they weren't. But we were working with programs that had already been leaked, and there was a concerted effort to dispel myths and to provide additional information to give better sense to the public about what was happening and what wasn't happening. That is not going to be the case going forward. So I think we look to our advice function in particular to understand what agencies are contemplating doing, getting in early enough to impact their thinking and their decision making, but not so early that we don't have an impact and not so late that we're just presented with a done deal. I would characterize it as a work in progress. I think we've had some non-public, very successful advice projects. We are currently working on a few advice projects. I think it is a credit to the board that agencies are coming to us now for advice, but over time, developing the relationship, how we're going to do the advice. And the fact is you could get advice that ranges from 5 different board members telling them to do 5 different things, or 2 board members saying don't, to 3 board members saying yes. We need to work on that internally and how we provide the advice. But the agencies are coming to us, and I think we have been effective in certain non-public situations.
In the private sector, there's something called privacy by design, where companies try to build in privacy in the design phase, not having to fix it after the product has been designed or the service has been designed. And I think that's one of the goals in our advice function, is to help the agencies get it right and not get beaten up down the road if and when something gets leaked, is to try to balance privacy and civil liberties with national security up front. And I think that that in the long term is beneficial, because I don't think any of us want to be constantly beating their heads over in the oversight process. We'd like to work constructively with them to get it right. One of the things that we have made clear is just because we provide advice doesn't foreclose us from later engaging in oversight. Not oversight of how well did they accept our advice, but oversight of how well is the program operating and is it striking the right balance going forward. Earlier in the spectacular earlier panel, there was the concept mentioned of the New York Times test. I like to apply the OMG test, which is the oh my God test, and I think we can do that. Sometimes I think it's natural that when you're starting to do an activity and it's going for a while, sometimes you don't step back and say, does this really make sense? And I think that our board can bring an independent perspective sometimes and just say, let's rethink this whole thing. It's not something you do all the time, but I think we are able to bring that to the table, and in some ways be an early test of how the public might react to some of these programs if and when they're leaked, and not have to pay that price down the road, but we can give them some feedback earlier on. There is one kicker here, though, in our statute, which I think all of us agree could probably use some considerable reform in various ways, but one of the kickers is that if an agency comes to us and says, we want to do a certain activity, give us some advice about it, and we say, as a board, don't do it, big mistake, and the agency does it anyway, we have to report to Congress about that exchange. Needless to say, that could discourage one from seeking advice, and so we've worked out some procedures where I think it's manageable for both sides, but that is a bit of a twist to our advice function.
Do you know the origin of that provision? That's very strange.
I think that congressional reporting is traditionally viewed as one of the fundamental mechanisms for oversight and ensuring that there are specific things that are related to or relayed to Congress, and the advice function may not otherwise be transparent to Congress. So I suspect it was a way that they thought would be a good idea to understand.
We do have the standard, in addition to that specific reporting requirement, we have the standard reporting requirement of a twice annual report to Congress on what we're doing, which is many agencies have that kind of thing. So we do have that.
And I read your most recent report today on the exercise bicycle.
Talk about scintillating.
It was quite well written. So let me turn to you, Rachel. Just step back for a second. This is sort of the bureaucratic management wonk in me, but you all are setting up an independent agency. I mean, really from ground up. Yes, you had predecessors, but you're really building, it's a different agency than, as you described, was previously contemplated or existed. And so you have to actually set this up. What are the challenges you've seen in just establishing and making an agency like this operate smoothly?
Well, David was spared some of this because the other four of us were confirmed about 10 months or so before David was. But you know, Congress establishes an independent agency in the executive branch. That's what our statute says. And the history was that the previous version of the board had been disbanded because of a sense that it wasn't independent enough. Congress did not direct any other agency to help us establish ourselves. And so, and the four of us who were confirmed are all not full-time government employees. So the four of us got confirmed. We all go off and get ourselves sworn in by various judges. And then we get on the phone and what do we do, right? We've got no office, no staff, no email system, no anything. So the four of us, we could tell very humorous stories, but you know, my first call was to the National Archives to ask, how do you comply with the Federal Records Act when you don't have a .gov email system? I called the Treasury Department to figure out, how do you get the money that was appropriated to us? Like, where's the money? Where does it come from? Where does it go? How do you spend it? My colleague Jim Dempsey went off to talk to GSA about how to contract with them to do the back office functions. Pat went and got an OLC opinion about whether we could hire detailees, even though the statute says the chairman has staff hiring authority. So we were all out doing these various things, and it was unbelievable. It was ridiculous, frankly. It was unbelievably frustrating. But we soldiered through, and by the time David was confirmed, we did have a couple of detailees, and we were sort of borrowing a corner of the skiff that is now our office. It was being used by another agency at that time. But it's those practical challenges are considerable. And then we have some ongoing practical challenges, like the fact, frankly, a multi-member board, it has advantages. You get multiple perspectives, but it also has disadvantages. You're slower. You know, you can't do anything without a vote of the board. We have 4 part-time members. I frankly think that's wrong construct. I don't, this job is not the type of job where you can show up one day a month like a federal advisory committee. It's a lot of time, and so doing it in addition to another job is really challenging. So there are some of those things, but we're managing those. But they're less than ideal. The final thing I'll mention is that we're subject to the Sunshine Act, and that's not something I think that Congress thought about when it passed our statute, because the previous version of the board was not subject to the Sunshine Act because only 2 of its members were Senate confirmed, and the Sunshine Act only applies if at least 3 quorum is Senate confirmed. So by operation of other laws, we're under the Sunshine Act, which means 3 of us can't get in a room and talk to each other about policy issues, and this is an issue that bedevils every multi-member agency. But operating under the Sunshine Act, when you do mostly classified work, is quite challenging. So there are lots of those things that we're managing all of them, but they're challenges.
Okay, last a couple more questions before we open it up. Step back. That's actually important just to keep in mind that you guys are trying to operate and build yourselves at the same time. Not an easy task. Get back to sort of just what should be your purpose, what should be your area of focus. And you drew a distinction, I drew it earlier, between sort of a strictly legal analysis of whether something is legal or constitutional, and an analysis of is something worth doing, sort of more of a policy analysis. I think I took your point earlier to say that your value add is more the latter than the former, since you have FISA court judges, federal district court judges, OLC, and a number of different entities who are making these legal analyses. But in the 702 and 215 context, that's largely what you did, right? I mean, that was largely the exercise that you all went through. Did you see those as being, A, am I right in that sort of, that assessment of your reports? And B, was that a product of sort of the immediate post-Snowden environment where you thought that was necessary?
Well, I dissented from the 215 report, and part of my dissent was that I thought that, frankly, going long on the statutory construction analysis, which had already been addressed by a couple, maybe a dozen FISA court judges, at least 1 U.S. District Court judge, various, general counsels, and so forth. The majority of my colleagues had a different view on the statutory construction than those judges did. And like David said, our statute refers to legal considerations. So doing statutory construction or constitutional analysis is not outside our jurisdiction by any means, but I just don't think that that's where we add value. So to my mind, the policy considerations, should the NSA have been doing this, that was a much more important question. Now, I also disagreed with my colleagues on that question, but to my mind, that was the question to be asking. On 702, we also did the legal analysis, but I thought that report was much more balanced in terms of also looking at effectiveness, privacy considerations from a policy perspective, and in that case, I was in the majority. Back to you.
Well, demonstrating the diversity of views on our board, I think we made a major contribution on 215 by conducting the legal analysis. People kept pointing to the FISA judges who've been approving it, a dozen or so. It took them several years to even write their first opinion approving it, and clearly, in my view, they missed major shortcomings of how the program complied with Section 215. The Second Circuit, as you may know, a couple months ago, ruled that the program was illegal and cited our report and our legal analysis in support of its conclusion. So I think bringing a fresh perspective on the legal analysis and being willing, where appropriate, to challenge the government is a critical function. Going forward, one of our recommendations has been to have a special advocate in the Foreign Intelligence Surveillance Court so that function can be engaged in on a regular basis, and Congress did adopt that recommendation, and now that's ongoing. But I think we certainly provide a unique value on our policy analysis, but I think in situations like 215, there was a critical need for someone to challenge the legality of the program, and the courts hadn't been meeting that challenge, and I think we were able to do that.
So if I could just add a couple of thoughts on that, drawing together where I think we add value and pointing to specific recommendations that we made. So I also dissented from the legal analysis in the 215 report, and I noted in a footnote that there are also consequences to engaging in a months-long legal analysis. with the very limited staff and resources that we had, it meant we couldn't take on any other projects. So whether or not that was the highest and best use of our resources, I thought not. But there were a couple of recommendations that we've made that I would point to as hopefully a sign of where we're going to go and where we add value. One of them was a recommendation, and I'd also point out that 20 out of the 22 recommendations we've made over time have been unanimous. And I think that's where our real weight is, to having bipartisan, unanimous, negotiated recommendations. One of the recommendations that we made was that the intelligence community needs to do a better job of assessing the effectiveness of its programs and then articulating the effectiveness of the programs. Because what you see time and time again is you're collecting this metadata, well, how many plots have you thwarted? And then the government comes back with some seemingly arbitrary number, and then it becomes a game to see how many of those can be knocked down as a plots thwarted. But that's really not a very helpful way of thinking about the effectiveness of programs that may be used to identify and prevent plots, may be used for triage, may be used for post-investigations. There are a whole range of uses for different intelligence programs. But we unanimously agreed that the IC needed to do a better job of evaluating the effectiveness. But getting the agencies to ask themselves the questions, getting the mechanisms in place in the agencies, I think that's where we have our highest and best use. Not telling them on a very granular level exactly how they should be doing it, but making sure they're asking the right questions. The second area that I would point to that I have some optimism about is there's a really thorny question with respect to 702. This is the content collection that is directed at non-U.S. persons reasonably believed to be outside the United States. But the fact is, the way that communications are routed, the way that communications happens these days, the fact is you're going to have incidental collection of U.S. person communications. And it has been a serious question for the agencies, for Congress, for the executive branch. Well, how much are we talking about? And so we worked with the NSA to identify certain metrics that they thought were feasible, that they could actually do to try to start answering that question. I don't think it's helpful for a recommendation to simply be, you need to figure out how much U.S. person information is there. We spent a good amount of time working with them to understand technologically what could they do, and what could they do in a way that wouldn't pull all of their operators off of doing the collection in the first instance. So I think that's the model that we want to look at going forward, which is implementable and positive, constructive recommendations.
Just sort of to try to sharpen the discussion on sort of what the objective, the value add of the PCLAB is going forward. Sort of back to the point we discussed, I think, at the end of the last panel. You know, if there's one thing, I think, to put in simplistic terms, one thing we learned from the Snowden disclosures is maybe there wasn't sufficient attention paid to the question not of can we, but should we. Best example, of course, is Angela Merkel's cell phone. Yep, the intelligence community had access to it. They got by public reports. They collected information from it. They could do it, but then the question was, gee, should we do it given the possibility of disclosure and blowback and damage to our relationships, et cetera? The White House then instituted a process by which I understand they've gone through sort of country by country and looked at, whether we should engage in those kind of activities as to those countries. So maybe that has been addressed to some extent. But then obviously you can ask that same question not just on a country-by-country basis, but sort of as to the whole range of intelligence activities. Do you see yourselves, and I open this up to anybody, do you see yourselves playing that role? Is that the role you see playing down there? In other words, is that the gap in the current oversight apparatus that's in place right now that you all could fill? And if so, do you individually actually have the background, are you situated to give that kind of advice?
This is where I go back to saying that the agencies need to be asking themselves the question. And asking, should we be doing this, is only the first question. Should we continue to be doing this? Federal programs, agencies, activities take on a life of their own, and the operators have an extreme risk aversion to discontinuing those programs. So making sure that agencies are continuing to ask, should we still be doing this? What need is it meeting? And is there a different way? So, for example, is there a way to use technology to make it more privacy protective and not just about collecting more? We don't have the resources or the capacity on a granular level to go in and tell agencies, you should be discontinuing this particular program because on the margins it seems to be slightly less effective this year than it is last year. But the agencies need to be asking themselves that question, and the fact that we could come in 3 years from now or 5 years from now and look at the program and do it and devote our resources to doing it, I think will provide a check over time.
I think the should we do it question is where we add value, but I don't think it's on the question that you're talking about, which is if we collect this intelligence, which might be foreign intelligence, it might be valuable, but it might create undue diplomatic risk or foreign affairs risk. That's a really important question, and I'm glad the administration is considering it now through a formalized process, but it's not our question. Our question is about privacy and civil liberties. And so it's, this may be legal, it may comply with the Fourth Amendment, you may be statutorily authorized to do it, but even so, should you do it or not do it because of the privacy implications or other civil liberties implications? And for me, one of the reasons that those questions are very difficult is that privacy is this very amorphous concept, which we had a whole day-long hearing on the question of what is privacy, which people made fun of us for because they said, why is the privacy board asking what is privacy? But it was really interesting because it elicited many different concepts of privacy, some of which are in tension with each other when you try to apply them in practice. And so, for example, if you're looking at a question of should one IC agency share information with another IC agency, let's take out the prospect of criminal prosecution later, but just one intel analyst sharing it with another intel analyst from another agency. Is that a privacy problem? Why? What definition of privacy do you use, right? Unless you sit back and think about those definitional questions, it's very hard to provide advice. And so because it's so fuzzy, for lawyers, it makes it more challenging than, say, constitutional analysis or statutory construction.
I think another element is that our view is not binary, which is do it or don't do it. I think sometimes there are ways of doing it differently that advance both national security and privacy and civil liberties. And I think one example of that is the 215 program. The board said, don't do it as a bulk collection program, do it with individual queries. And again, the administration, the intelligence community, and Congress ultimately adopted that position. But when the new program was rolled out, which is the more targeted collection of phone records, the intelligence community said, by the way, we're actually getting more information than we were under the old program. And so about phone records and access to more phone records. And so that's an example where we actually are better on the national security side, more information, and also better on the privacy and civil liberties side. So sometimes rethinking things can maybe even maximize both.
Okay, I want to go ahead and open it up for questions. Mr. Bagnall?
Four questions real quick for
might get one
any and all panel members. Joel Bagnall. No, I'm teasing. I had the opportunity to work on the national security staff for about 7.5 years, from 2001 to 2008, and ended up being Ken's predecessor, deputy for a while, as he came into the last year of the Bush administration. How do you choose your work priorities?
As a board.
I mean, as a board, right. I mean, how does that actually work in practice? Because there's ad infinitum opportunities for you to review things that apply to your mandate. So how do you go about choosing the priorities? Second question is, are you involved in pre-decisional CT policy deliberations? Are you involved in interagency meetings, counterterrorism security group reviews, things like that? Or is it just after the decision's been implemented, then you kick into action? I'm curious to know if you're involved in policy deliberations. And what are the 2 to 3 most significant barriers to the success of fulfilling your charter? You've touched on a couple so far in the discussion, but I'd like to know what you think the most significant 2 or 3 items are. And then what would you recommend changing in the statutory language going forward with regard to the PCOF charter?
Okay, you need to interview us later if you want to ask that many questions.
Do the whole congressional thing. We'll have to get back to you on that, sorry.
I can start with a discussion of the first one. So in developing our agenda, we've approached this as an ongoing process. From the beginning, actually even before David was confirmed, we met with members of the public, we met with non-governmental organizations, we met with IC elements, and we met with our committees of oversight to get their understanding of what we should be looking at. We have limited resources. We can't look at everything. So some of the factors that we may take into consideration is whether we can make a unique contribution. Is this an issue that everybody and their brother is already opining on? Is it we're not limited by statute to U.S. person protections, but the fact is, given how the Constitution works and how policy has developed over time, we have also considered the question of whether or not there's a greater likelihood of impact on U.S. person privacy and civil liberties. But this has been an ongoing process, and the board decides as a board formally to adopt an agenda, and we've done so through public meetings. That said, there's also projects that are given to us. So we have another legacy of our statute is we have been charged with looking at the information sharing environment. Some of you may remember the information sharing environment from approximately 04, 05. So we have to look at that periodically because it's in our statute that we look at it. We have a role in cybersecurity in the executive order regarding critical infrastructure. So we have a consultative role in what the agencies are doing in terms of informing the public about their activities. PPD 28, which was mentioned earlier, the president, I think the best way to do it was invited us to do a report on the implementation of PPD 28, and we have accepted that invitation. But the core areas are through a consultative process with the public, with the NGOs, with our committees, with the agencies to develop our agenda, and it's an ongoing process.
I can tackle the second question, which is...
I don't even remember the second question.
Which is, are we involved with pre-decisional matters? Under our statute, we're an independent agency in the executive branch, which sounds like a non sequitur. But actually, I think it's worked to our favor. On the independent side, we don't get clearance from OMB and the White House on what we say and do. We disagreed with the White House on the legality of the 215 program, but as a board, we could vote and do that. And I think that makes it as critical to our credibility that we can be independent. But on the second part of it, which is independent agency in the executive branch, it means that we can have access to deliberative materials, privileged materials, because we are part of the executive branch. I think that's been an enormous advantage we've had, say, over congressional oversight, is we get into the tent, and especially obviously in the advice context where we get invited, they show us draft documents, and we protect the privilege and so forth, but we are able to deliberate with them and provide our feedback. So I think that's a big plus of the way the board has been situated.
But if you're asking a practical question of are we in, the PCDC, the committee, so no, we're not.
Invite yourself to one if you have an issue that you want to address.
That is a good question that you should ask
Where's
somebody
Brett?
at the
Where's Brett?
NSC.
Yes.
Yeah. So we're not in that process. We are our advice function is still developing, right? So the administration has come to us with some advice requests, and they've recently come to us with a couple more that we're working on now. So that's encouraging, and I hope they'll come to us with more. But the real question is whether we can get them to come to us in time for us to provide actual input. Because if they come to us when the thing is already basically baked, we can make recommendations, but you know how slow this process works. It's virtually impossible to make a real substantive change that late in the process. So I'm optimistic. We're working on it, but I think, part of our challenge is we need to provide them advice that is constructive. And to provide advice that is constructive, we need to understand how they work, what their mission is. And I think we have a little bit of a challenge in demonstrating that we have the capacity to do that. I think we're getting there, but with more experience, more interaction, and more work, we'll get there. But we're still working on establishing that trust and credibility.
And I
To,
guess-
sorry,
go ahead.
to the extent that you were asking whether or not we have an operational role, I don't think that's what you were asking, but we do not.
Right. And I guess combining your last 2 points real quickly, which is barriers and changes. I guess I'd want to add to the comments previously, which is I think having part-time board members is a barrier to proceed to deliberating among ourselves and to operating efficiently. And so I think it would be very helpful if our statute were amended someday to have full-time board members. I would grandfather in existing board members, but I think on a going forward basis, it's hard for the board member to balance outside jobs and the board, but I also think it would benefit the board's efficient operation and deliberative process itself to have full-time board members. And then playing off of the deliberative point, I think the Sunshine Act, the board should not be subject to the Sunshine Act. It greatly impedes our ability to deliberate. The three of us can't go out in the hall and talk about 12-333, assuming it was unclassified discussion or something else, because the Sunshine Act will require it to be an open meeting. The Sunshine Act is absolutely well-intentioned, but I think in a board, as Rachel said, that deals with a lot of classified information, and especially a board with part-time board members who are coming and going, the chance of deliberating and talking to each other on an ad hoc basis, I think adds tremendous value to our ability to strike the very weighty judgment we've been asked to strike between national security and privacy and civil liberties. And so the more we could talk to each other, I think the better. And unfortunately, I think the Sunshine Act impedes that discussion.
Adam? Oh, sorry.
Two quick questions. First, to what congressional committees do you report? Where's jurisdiction within the Congress? Second, having been involved in creating the FISA court, getting it started, help me understand foreign intelligence surveillance court. What's the role of an advocate proposed to have in that court?
Well, the first one, I think there's sort of an informal reporting process on the Hill, which is, understandably, we report to the intelligence committees on the House and Senate side, but the Judiciary Committee, which confirmed us and also has a great ongoing interest as well.
So Judiciary is where you're confirmed.
Yes.
Yes.
We're confirmed by the Senate Judiciary, and we do regularly keep in touch with House and Senate Judiciary, but also with House and Senate, the Intel committees.
For your second question, I think we had unanimous recommendations, but probably different reasons for joining the recommendations. In my own view, based on my personal experience within the Department of Justice, the FISA court was anything but a rubber stamp. But it was widely perceived to be a rubber stamp. There was a lack of information, and I think deliberate misinformation about its functionings and the rigor of its functioning. And for me, one way to approach that and to restore public trust in the operations of the FISC was to add a different voice, to assure the American people that on questions of novel interpretations of law, that there was a voice in the process and that the judges would be considering these other arguments. I hope that we were sufficiently clear that the judges would be making the determination as to whether or not a special advocate would be helpful or appropriate in a specific case. In our recommendations, there was no entitlement to a special advocate or even a right of appeal for the special advocate. But in terms of restoring and building public trust in what, in my experience, was a highly effective, rigorous court, thought it was necessary.
Yeah, I think anybody who's had any experience in practice with FISA or the FISA court knows that it's not a rubber stamp, and they know the incredibly rigorous process that goes on with the agencies through DOJ before you even get to the court, and it's almost a quasi-adversarial process with the bureau, say, and justice lawyers who are going to appear before the FISA court. So, but the public, like Beth said, the public didn't understand that, and there is a very widespread and probably ongoing conception that the court is a rubber stamp. And it's also important to understand what we recommended, which was not that the ex parte nature of the FISA court be altered in any fundamental way, because your typical, Title I FISA application, we want to wiretap this particular terrorist, right? there's never going to be an advocate in that proceeding. It's designed for something like the first time the 215 program came before the court. It's novel, it's programmatic. The court might decide, I might want the views of an independent party. So the statute sets up a mechanism where the court can appoint a panel of advocates that can be drawn upon in those situations, and they'll be cleared and everything. So it's quite limited.
The first time
There was another aspect to it, too, putting aside the special advocate. I think what you saw and what we saw in 215 and 702 was no deliberate abuse. However, you did definitely have circumstances where there was an elaborate game of telephone happening where operators and technological folks told agency lawyers something, who told the Department of Justice something, who told the FISA court something. And by the time it came all the way up and went all the way back down, compliance incidents arose. Not, again, because of a deliberate attempt to mislead the court, but just there was this game of telephone. So we also encourage the FISA court to make use of technological experts to really get directly to, okay, I'm saying that as a Fourth Amendment matter, you need to do X, and making sure that that is then technologically possible and accomplished.
Yeah, I just wanted to quickly add that one of our first workshops, maybe the first one, Judge Robertson is a former FISA court judge, spoke to us and said, as a judge, he likes to hear one side first and they sound awfully persuasive, and then the other side and they sound awfully persuasive, and as a judge, you work on trying to reconcile those views. But when he was sitting on the FISA court, he didn't have that opportunity to hear the other side, and so he felt challenged, particularly in novel cases of novel legal or technological issues or programmatic approval, and that at least, I think, for my sake, got me thinking about that issue.
Okay, this patient gentleman back there, you still have a question? Been answered? Okay.
He's had his hand up.
Oh, okay, gentleman back here.
Hi, thank you. I have a specific question about the 702 report. I was one of the people that did not love the board's report on that program or that set of programs. Specifically, I have a question about minimization, which is a process that goes on throughout the entire program of protecting Americans' privacy, going through collection, retention, and so on. Specifically, I'm interested in minimization protections for dissemination, where the major, or at least one of the major protections, is masking Americans' identities before reports are disseminated. So if any of our if some of our names, those of us who are American citizens, our names were included for foreign intelligence purposes, or if there wasn't a foreign intelligence reason to have the name, it would be removed. It would say U.S. person or whatever identifier is used generically. My problem, the criticism I want to make, and then I want to hear what your response is that I actually think this kind of masking has been taken up in literature on data mining and privacy. And in at least computer science parlance, just because that's where I come from, the literature has said pretty resoundingly that it's vulnerable to what's called de-anonymization attacks, where basically you take some information about someone where one form of identifying information has been removed, like their name, and it becomes very easy if you correlate it with other data sets or you do statistical attacks to figure out who that person is. So, for example, if a report was put out on me, just using an example, and my name was removed from it, using just a few data points, it could be easily inferred who that person is. They could say, oh, this person attended the Intelligence in American Society conference. That already limits it to a certain set of people. This person is also a computer science undergraduate. That narrows it down more. This kind of stuff was actually researched on and published on by a professor who used to be at UT, Vitaly Shmatakov. He infamously wrote some articles that got him in trouble with Netflix and other companies who had released anonymized data sets, and he proved that they were not anonymized. So anyway, I'm curious about what you think about that. I think that this identifying masking does not work, demonstrably so, and so I'd like to hear what you think.
I'm familiar with those Netflix articles, and LaTanya Sweeney, as a Harvard professor, has written on this as well. De-identification is a challenging process. I think what makes this context of 702 different is that this is not information that's going out to the public, and where anyone could try to figure out retroactively who was involved. This is information that's being shared in the intelligence community. And so I think it's a pretty good system. I'm not sure if there's a better system out that certainly someone could consider, but I don't know what really the alternative is in terms of sharing valuable intelligence information. I would add that one thing that at least I noted is that the minimization procedures also require deletion of information that doesn't have foreign intelligence value. And Judge Wald and I dissented from the 702 report and said more should be done to monitor the agencies following that part of the minimization procedures, and even suggested that the FISA court appoint a special master to review how well the minimization process is going on, because that's really part of the overall Fourth Amendment reasonableness of the procedures, and that seems to be lacking, and so that there needs to be more rigor in that type of minimization.
So can I build on that really quickly in two ways? One, I think your question is an interesting one, but there's a really simple process, actually, rather than picturing an agent or an analyst attempting to piece together and find the identity. If they have a reason to believe that they need the identity, there are processes for them to simply go back to the agency and say, can you unmask this? So it's much simpler than what you're anticipating. It's a much different scenario. But something Rachel said earlier, which is we all have very different conceptions of privacy, and it's amorphous. So I think that David and Pat's suggestion that you need to do more in terms of minimization has its own privacy risks to it, because it's often said, well, you need to review the information to see that it's not foreign intelligence. In my view, that is less privacy protective, because the alternative is you have a situation where information is collected, it's not ever reviewed, and it ages off at the end of some period. But there are those who suggest that in service of my privacy, someone should be required to actually review the communication that they would never otherwise review. And so that, to me, is less privacy protective, but it is what perspective you bring to it. I have less of a privacy concern about my information being in a government repository and aging off, and the fact of it being in a repository, than I do about some requirement that someone affirmatively review that information to determine that I'm innocent and that it's not foreign intelligence.
I just want to respond to
Right,
that.
even using technological filters. I didn't say that you suggested that it be manually reviewed, but there are those who suggest that there should be manual review in service of our privacy.
Yeah, I just want to clarify that our recommendation was for information that's already being reviewed. As you look at the information, if it doesn't have foreign intelligence value, it should be deleted. We did not take the position that we should look at everything, because I agree that could have its own consequences. But analysts review information all the time and never hit the delete button on the information, and that's inconsistent with what the minimization procedures provide.
Except that sometimes a guy is a pizza delivery guy, and then it turns out a year later that, in fact, he's also the pizza delivery guy for the next suspect, and 3 years later, he's also the pizza delivery guy for 3 other potential suspects. So it's hard to determine on the front end what is or is not foreign intelligence.
This is exactly what I was talking about when I said that there are concepts of privacy that can conflict in practice. So you're looking at, should we pick minimization procedure A or minimization procedure B? One protects one concept of privacy and infringes another, and the other does the opposite. So there's no real solution to that problem, except that I think when people are talking about privacy, they need to be a lot more specific about what privacy right they think is being infringed and how, instead of invoking privacy in some generalized and non-specific way.
Looks like we'll have to keep an eye on pizza delivery guys. Steve, if I could, Steve, just. You have a question?
Yes,
Oh.
and sort of programmatic notes. So I'll make you a deal. We'll extend the panel discussion by 5 more minutes because we've got a lot of interest, but you have to listen to my program announcement. That means we're due settled in upstairs at Salon C for Lisa Monaco's remarks at 12 o'clock noon. So we'd ask you to cycle pretty quickly. And in exchange for that, you have to answer my question. So this is recycled from the last panel. And one of the reasons that we're so focused on intelligence supervision and oversight, and that we're doing this conference in public, is because we think there is, as has been mentioned, a bit of a trust deficit that was revealed after Snowden. It's not clear that the American public had the amount of trust and confidence in our security organizations as they might have, or as many of us thought they did. And so your organization, your agency, was stood up, made deliberately independent. You are part of the demonstration by the government to the public why they should have confidence in their national security organizations. So what can you say about your outward-facing perspective? So not only are you policing intelligence activities internally, making them better, more privacy respectful. But what are you doing to demonstrate, to appear to be doing that, to demonstrate to the American people that they should have confidence and that you're part of an effective process?
Let me expand that question a little bit, and then my colleagues could answer it more specifically. But I want to add in the international perspective as well. And Rachel and I have had the opportunity of speaking in Vienna and Berlin to legislators about what controls there exist on the intelligence programs in the United States. And just a few weeks ago, I was in Paris meeting with the Article 29 Committee of the European Union as they were negotiating the safe harbor to give them some assurances that 702, for instance, is not a bulk collection program. The European Court of Justice sort of suggested that, and I was there along with someone from the Director of National Intelligence staff to say, no, have confidence. We took a hard look at it. We're independent. We call it the way we see it. 215 we call one way, 702 we call it the other. 702 we said is within the law. It's targeted program. It's proportionate, and I think that's a way to give confidence not only to the American public but to the international public that these programs have had a hard look.
I think our public-facing component is important because I think Beth referred earlier to the demystification and educational benefit that we had with 215 and 702, and I think that was very important. I also think, though, that we add as much value. Really, where we add the most value is if we can engage with the agencies early and get them to adjust their conduct before the fact. That's our real value add, I think. So the public facing is important, but it's not more important than the internal facing work, which unfortunately people won't know about. So it won't serve that that confidence building function, but it's where we actually change things.
Steve, can I just raise one more theme just to stir the pot, and then I know I gotta go. So I'll start stirring right now. So you have all talked about your reports on 215 and 702, which were, they're confined to sort of one program. Your current project is to review 12333, Executive Order 12333, which really is basically a roadmap that sort of sets out the lanes in the road for the various intelligence agencies, and it's the internal guidance for the whole intelligence community. So it's pretty much everything the intelligence community does. So, a cynic or a critic would look at that, your mandate, and say, wow, it looks like, and this is the terminology I used last night, looks like you guys are giving yourselves a license to just go rummage around in the intelligence community and look at everything and then sort of purport to opine on the appropriateness of the whole intelligence enterprise. Beth, you voted for this.
I did.
And so, am I right?
You're
Would
wrong.
the critic be right?
So the work plan had a couple of components to it. And again, this is where, the Sunshine Act is interesting and so could potentially have some benefits in terms of public education, telling public what we're doing. We have a work plan that we had to vote on. We voted on it publicly in a hearing that we noticed and told the American people we're going to be talking about this in 10 days. And it had a couple of aspects to it. First, it begins with our mandate, which is counterterrorism related. And that was a message both to the public and to the intelligence community that we do not view ourselves as having a license to rummage through what the agencies are doing. We suggested that we would write a public report on what is 12333, that this is a widely misunderstood document. I think it's been described as some vast grant of authority to do mass surveillance all over the world. My own view is it's a reflection of the president's authority and statutory authorization, and it gives lanes in the road and has a couple of thou shalt nots to some of the agencies. But doing a public report, because there's widespread misunderstanding about what is 12333. That public report could, to the extent possible, be informed by select deep dives, and those deep dives, in turn, are limited to counterterrorism activities.
I was the lone dissenter from this work plan, so I will tell you why. Although, if you look at the language of my dissent and of Beth's public statement, they're remarkably similar. But I dissented because the work plan that the board adopted suggested that our public report might be able to make analyses or recommendations about 12333 generally, and I do not think that could ever be possible given the limited scope of our jurisdiction and the limited number of reviews that we've done. So 12333 is saying that we're reviewing 12333 is ridiculous, because it's the entire intelligence community. It's the construct for how the IC operates, for how agencies interact with each other, and then it provides protections for U.S. persons. So we've modified the notion that we're looking at 12333 somewhat and saying we're going to do a public report and some deep dives, but 12333 covers not just CT, but everything the IC does. It covers human intelligence, it covers battlefield intelligence, it covers counterproliferation, nuclear, I mean, it's everything, and much of that is outside of our jurisdiction. So we're going to take 3 deep dives that we've adopted, look at 3 particular CT activities under 12333. There is no way that, having looked at those 3 classified programs, we could make overarching recommendations about 12333. And so that's why I dissented.
Steve, are we at time?
I think we need to wrap up.
Okay, well, look, please join me in thanking the panelists for a really good discussion. Nicely done.
Yeah.
You didn't announce it.
I didn't want to distract it. No, it's not all about me.
You didn't announce we were hiring staff.
It's all about you.
David, you had one job, which was to say we're hiring